So, good morning everyone, and welcome to our Colloquy 6, which we are recording here in Toowoomba. And today we're going to cover one lecture, which is lecture 9. And we'll cover chapter 9, and we'll cover chapter 10 in Springfield. All right. So quickly, we're going to go and talk about something called intention. Now remember, last week we talked about the general approach to analyzing contracts, and we said that you have 7 elements now where you have to, in the past, for example, for negligence there were only 3, and for crimes there were only 2. Now the first 3 elements relate to the existence of what we call the simple contract, in the sense that it is a contract that requires a certain form. In particular, it requires consideration, or rather it doesn't require a certain form, but it requires consideration, as opposed to a formal contract. And we said for the existence of a simple contract, you need to have 3 elements. The first one was agreement. So there has to be agreement between the parties to this contract. And we said that the traditional approach is to look for an offer and a corresponding acceptance. The second element is the intention to create a legally binding relationship. And of course, the third element is consideration, which will be the topic for our colloquy in Springfield on Thursday. So this is the second element. What is this legal intention, and why is it needed in a contract? So there's a relationship between having this intention, i.e. intention to create a legally binding relationship, and the existence of an agreement between the parties. Okay? So think of this as a signifier, and the agreement is the signified. Intention is required for us to see that the parties actually got into an agreement. So as it says, the issue of intention is going to assist courts in determining whether or not the parties have reached an agreement. So without an agreement, there can be no simple contract. The contract doesn't come to existence, and that's why you need to look for intention. What happens if there's no intention? Then the agreement, even if you reach an agreement, okay, it's not enforceable. Okay? So as we said, if I, for example, agree with a friend to meet on a certain date, at a certain time, at a certain place, okay, for lunch, for example, okay, even a working lunch, I can't turn around and say, you know, you have actually breached this contract between me and you, and I'm going to actually sue you for it. There is no intention to create a legal relationship, so it's not enforceable. You can't take it to the court, even though we have an agreement. But we didn't actually intend for that to become a contract, i.e. to become legally binding. 2 types of intention. One is known as express, and the other is known as implied. Express intention means that you have something expressly stated in the contract. So if you have a written contract, they will say what they are intending to do. This is usually in relation to business agreements, because they are drafted, you know, in a way that's actually towards a business arrangement. So they will put it expressly. And usually it's in the negative. For example, binding in honor only. So I'm negotiating with someone, and we're going through this contract towards finalization. But in order for me to protect myself and to make sure that everybody understands that I'm not at a stage where I want to become legally bound, I would say, or put something in this contract to say something binding in honor only. So you can't actually take it and enforce it against me in a court of law. Okay. Implied intention, which is the more difficult one to deal with, that's when you have, so arises where the intention of the parties is not expressly stated. So the court has to try to determine what it was that the parties intended from their words and also from their actions, conduct. And this is the important part of this colloquy for today, which is going to look at, of course, chapter 9. We're going to go through the cases in just a minute. But there's a difference, or at least there's a presumption, okay, that there's a difference between commercial and non-commercial agreements. Okay. So if there's a non-commercial agreement, so if it's between family members, or something like a social arrangement between friends, or voluntary agreements, then the type of this agreement is usually characterized as lacking serious intention. So the presumption is that the parties to this agreement do not intend to create a legally binding relationship, which means that they don't intend to take this to court. So the onus is on the plaintiff to establish the parties did in fact intend this to be legally binding. If you are the one who's moving this, if you are the one who's bringing this to the court, you have to convince the court, even though there's this presumption, it's going to be rebutted, and it's going to be rebutted on the evidence. On the other hand, we have commercial agreements, and these commercial agreements are usually presumed to intend to create legal relations. But again, there's an onus on the plaintiff. If you want to do otherwise, the plaintiff can show that here, in this particular business arrangement, okay, these relations were not intended to be legally binding. All right. Let's then start on our case analysis, which is going to be the rest of this colloquy for today. And hopefully that will give you better understanding of what we've just talked about. So we are doing chapter 9 for today, and we are on page 242. So we're starting with Masters. The case on page 242, Masters and Cameron. So again, it's a High Court of Australia case from 1954. And the facts are as follows. The parties signed a memorandum, which was a letter of intent, okay, drawn up by the vendor's agent, which contained a clause to the effect that this agreement is made subject to the preparation of a formal contract which shall be acceptable to my solicitors on the above terms and conditions. So this is a memorandum signed by both parties, but in this memorandum they stipulated for this clause, talking about a formal contract and approval by solicitors. Now the purchaser, which is Masters, wanted to withdraw from the agreement, and the question was who was going to be entitled to the deposit. So there was a deposit here on the sale. What's going to happen to this deposit? If the contract was enforceable, it went to Cameron. Okay? They are the ones who are selling. And if it wasn't, it went to Masters, who is the buyer. So the High Court went about looking at three possibilities. The first, had the parties reached finality in arranging all the terms of their bargain and intended to be immediately bound? Okay. Or had the parties agreed upon all the terms and intended no departure from or addition to that which their terms implied? Or Was it the intention of the parties not to make any concluded bargain until they had executed a formal contract? So, did they finalize all the terms? Did they finalize all the terms and agree that there can be no departure from these terms? Or did they just simply say, we'll leave the finalization of all of this until we execute the formal contract? Their decision was that this agreement, this letter of intent, was not in its final form. Why? As it had to be acceptable to Cameron's solicitors. So the seller's solicitors had to look at this agreement and then say, yes, we're happy with it, and we can now finalize a formal contract. Therefore, there was no intention to be immediately bound, meaning you cannot actually take this letter of intent and go to the court, and say, I want this to be implemented, or I want my deposit back. And therefore, there was no contract in existence, and Masters was entitled to the return of his deposit. Because if there's no contract, you just give them back the money that they put in because the sale is not going through. Let's look at some case reflection. It's early in the morning, but let's look at some case reflection. Will the use of an expression, so if you are now someone in business and you are drafting a contract, or someone brought this draft to you to look at, and you find this expression, it says subject to contract. Okay. Would this expression suggest that the parties are not intending to enter into contractual relations? What do you think? If someone puts something in the contract that says, we're agreeing on this, we're signing it, it's in writing, but only subject to contract, is that enough for us to conclude that these parties do not intend to be legally bound?
But isn't a contract a legally enforceable agreement between two parties? So saying that subject to contract seems they do want to be legally bound because the contract's an enforceable agreement, as I just said.
Yeah, but if I said something like subject to contract, does that mean, so this is not the contract, this is like a letter of intention? Okay, so letter of intent or a memo?
So there's been no say sign here to agree?
No, we're going to sign the memo.
Okay, but
we're going to sign the memo. But in the memo, we're going to simply say subject to contract. Yes?
I think to be on the safe side, it's best to assume that they may pull out. Probably may. Right. Keep that in mind. I would say 80% keep that in mind. And then if they do go ahead, yeah.
So in your mind, if we are talking about negotiations, we want to buy and sell something, and I say let's write a memo of understanding, and in that memo of understanding, I want to say something subject to contract. Does that mean that I want to be bound by this memo? Does that mean that I want this to become something that you can now take against me to court? Most likely not, right? Okay. Is that water tight in the sense that you can't actually go to court even if I put this statement there? Can you think of certain instances where even if I say subject to contract, but because of the nature of the detail and the nature of the terms in this memo, that would be defeated? So I will just remind you of what we used to talk about previously in relation to exclusion clauses. Remember? We said you can put an exclusion clause in a contract. Remember we talked about negligence and the woman that was standing in the bus on a European tour? You can put an exclusion clause. But it doesn't mean necessarily that that exclusion clause is going to be effective. Remember when we talked about that particular case, we said the reason it wasn't effective is that she was standing up. And your exclusion clause was talking about someone who's sitting with a safety belt. So the same thing applies here. It all depends on the details. Okay? Generally speaking, yes, if someone puts something like this, they don't they don't intend to be legally bound. But there will always be exceptions. You can always find a certain set of facts that will give you a different result. Let's look at another example. Let's go to page 246 and Trevi and Grubb. Supreme Court of Victoria, 1982. This was a 3-person syndicate. They won the lottery. The ticket was in the name of the defendant. And the defendant refused to share the prize with the plaintiff. Do we know what we mean by syndicate? You know what they're doing? Can someone explain that to us? What's happening here? You have 3 people, they form the syndicate. What is that?
They're all putting money into the ticket so they can buy something.
Okay. So, they're sharing the cost of what? Of the lotto ticket. And it happened that one of them won. They kept buying these lotto tickets. One of them won. And the understanding would be what? If you have the syndicate, you're sharing the cost, you would split the profit. You will split the prize. So what is the problem here?
The problem is that he wants to keep the 218 grand for himself and not split it.
So what made him, what facilitated that? Why do you think he can do that? Why would he be able? So even though there was the syndicate, and they're putting all the money together, but it was one person that was buying the ticket, and that person is the defendant. Grubb.
It could have also been that that person wasn't paying his share of the ticket, so he didn't think he deserved it.
Okay, maybe the plaintiff was not actually paying his part. You know, we said that we all gonna put money into this and we'll buy the ticket together. Maybe this guy, the plaintiff, was not actually contributing to this cost. All right. The issue. So that was a speculation. We're not going to go after that. We want to just focus on whether there was intention for them to split this prize or not. So was it just a friendly agreement? And as we said, if you have a friendly agreement, what does that mean? There's a presumption that the parties, the syndicate, what? Did not intend for this agreement to be what?
Legally binding.
To be legally binding. Which means what? You can take me to court. So if I win and my name is on the ticket, I take the money. That's what they're saying. If it's a friendly agreement, social arrangement, then there is no intention to be legally bound. So don't take it too seriously. Even though it's what, 200,000 something. What is the other interpretation? So was it just a friendly arrangement so that it could be said that there was never an intention on the part of the parties to enter into legal relations or share the prize? The other, of course, alternative is that it is a business kind of arrangement, or you could say it is a social arrangement, and the presumption is, you know what a presumption is? The starting point. The presumption is there is no intention to be legally bound. However, because it's a presumption, you can rebut the presumption. You can argue in the alternative. So you could say, on the evidence, so what's the evidence? On the evidence, in fact, these people, the syndicate, was in fact intending to be legally bound. Okay? So the distinction is between something that's presumed and something that's deemed. If I say that I presume that there's no intention here, I'm opening the door to the possibility that you can argue on the facts that there is evidence here that in fact they wanted to be legally bound. But if someone says something is deemed, So it's deemed that there's no intention here. Then this deeming means that you can't argue around it. Okay? Just clarification between presumption, something is presumed, something is deemed. Here we're talking about presumptions. So you still have this ability to rebut the presumption by providing facts, i.e. evidence, to convince the court otherwise. What did they say? While, so the minute you see the word while, you know, aha, they're gonna flip it to the other way. While this was a social arrangement between friends, the nature of the agreement was such that they must have contemplated that it would be enforced. So again, the nature of the agreement. What do they mean by that? There was a contract and the plaintiff was entitled to a share of these winnings in proportion to her contribution. In this case, so giving you more facts, the defendant was obliged to give 25% of the winnings to the plaintiff to correspond with the 25% she contributed to the regular entry fee. So note, there are only 3 people here, but she gets only 25%. So they're not contributing in equal shares. It doesn't matter. They agreed that you give me 25% of the cost, contribution to the entry fee, then you get also 25% in the winnings. It doesn't matter how they decided to structure this. What's important is that there was an agreement, and the nature of this agreement was such that they must have contemplated that it would be enforced. Alternatively, you can just look at the number. $218,000, was it? Okay. We're not told, of course, over time, how much this or the syndicate as a whole contributed toward the cost. Have they been doing this for how long? How much have they paid in cost? But it doesn't matter. What matters is look at the winnings. Something like 218,000 is a serious matter, as one of you said. So that should be enough in its own to convince the court that even though they are friends, they didn't just intend to have something for fun. This was something for actually winning, if they win, actually making money. So they talk about an outcome in an English case. In that case, okay, it says the court held that the nature of the agreement between the parties was such that they must have contemplated that it would be enforced in the event of them winning. Do you think that the decision in this English case was fair? So let's go and unpack it a little bit. So this is from 1955. Simpkins and Pays. The defendant, her granddaughter, and the plaintiff, again 3, had regularly entered a competition that was run in a Sunday newspaper. That was a lotto. This is a competition. 3 people, 3 people. Note here that there is also a familial link between 2 of these people, the granddaughter and the defendant. Again, the entries were in one person's name, the defendant's name. But they shared any costs. So those other 2 people were contributing to the cost of these tickets. There was an agreement that any prizes would be shared. Okay? And eventually, one was successful. Again, the defendant refused to share the prizes with the plaintiff. Do you think the decision in this Trevor and Simpkins cases were fair? Or Trevi and Simpkins cases were fair? So, two cases, one in Australia, one in the UK, one from the 80s, one from the 50s, but they both say the same thing. We are going to rebut this presumption, even though this was a social arrangement it is actually intended to be legally binding, which means that you have to share the prize money with the other two people in the syndicate or the group. Any comments? So here we're talking about, again, the law and fairness. Okay, someone? Anyone? Yeah. Anyone?
Yeah, so, even though there is no actual written thing saying we agree to these terms, even because it's just, as you say, it's just a social.
But it says that there was an agreement.
Yes, I was getting to that, because even though there is no written contract and there's no sort of like evidence that this was a thing, because they agreed to, because they all put money into the thing and they agreed to share any money that came out of it, that's, even though there's no contract, it's considered a,
Okay, let's unpack it. Let's unpack it. Step back a little bit. Let's ask this question. Let's talk about this English case, Simpkins. We said that the first stage of your analysis should be what? Whether a simple contract exists. Does a simple contract exist in this case? No, I don't want you to say yes or no. I want you to go through the elements. Always remember that, and we'll emphasize it even more later, but remember that never say yes or no. That's not what I'm interested in. You know, the answer, you can finish actually the exam, because the exam is only 2 hours. So you will run out of time, which is normal. And you will never come to a conclusion, but you will get a high distinction. Because I'm not interested in the conclusion. I just want to see that you can do it. I don't care whether you do it to the very end or not, but you give me yes or no, it's not the issue. So again, the first thing to do is to ask whether there's a simple contract, existence. We said that there has to be 3 elements. The first element was an agreement. Is there an agreement here?
Yes.
How do you know?
Well, it says there was an agreement.
Because you're told. Don't go looking for offer and acceptance. Here, on the facts, it's going to be difficult for you to see the offer and the acceptance. As long as you are told that there's an agreement, there's no legal issue. What's the second element? Intention. That's what we're talking about here. That's the legal issue in this case. What about consideration? And we said last week consideration is simply the price you pay for the promise of the other party. Were the people in this syndicate or this group paying any price? And that's what they were paying for entering into this competition. So you can see the first and third elements are straight on the facts. But the intention is where you have to argue, okay, this is a social arrangement, but there is this rebuttable, the possibility to rebut this presumption based on the facts. Okay, let's do it one more time. Let's go for Cohen, page 247. This is 1929. At the time the parties were engaged, the defendant had promised to pay his fiancée an annual dress allowance. After their marriage, the defendant paid the plaintiff this allowance on time, quarterly, for 2 years, 8 times. The parties eventually separated, and the plaintiff commenced an action. So look at the words and look at the language. Many of you sent me their drafts for the assignment, and the scenario uses exactly the same language. They want to take action. No one is picking on that. When they say they want to take action, more likely than not, they're telling you they want to litigate. What do you think? Should they go to litigation? Should they go to court? And people just ignore that. Sometimes some of the scenarios tell you that, oh, they want to do defamation or class action. So what are they telling you? Should they do litigation here? What do you think? So don't just ignore that and go talk about mediation or something else. They are telling you, look, they want to do this. You think this is a good idea? That's what they mean here. They want to commence an action. Okay? So she wants money. She wants the money. This is back in 1929. But let's see how they analyze this. While there was no doubt that the husband and wife had made an arrangement, the question was, had the parties intended a domestic arrangement that was legally enforceable, or a domestic arrangement that was not legally enforceable? What is the initial position? The presumption, because it is a domestic arrangement, there was what? Was their intention to be legally bound or not?
Yes.
The presumption at the beginning, because we are friends or we are family members, you think we want to take each other to court and destroy our relationship? You know what happens to people after they take each other to court?
They get divorced.
All kinds of things. So when you go to court, you know that this is going to be terminal, usually. So the intention then wouldn't be found if you think that these people want to continue their relationship. So if it's a domestic arrangement, the presumption is that you don't want to destroy your relationship. So there's no intention to go to court. However, sometimes people actually do want to go to court because they don't want that relationship anymore. So that's the question here. Is it the presumption, or can you rebut this presumption? The decision. So if you're doing the analysis in a question in the exam, you start from the arrangement. You start from the agreement. So you have to have three elements. There's no problem with the agreement. There's no problem with the consideration. We'll look at that later on. Maybe there's a problem with consideration. Keep that in mind. Today we're talking about intention. What did they say? The arrangement was a domestic one because the parties did not intend such an arrangement to be attended by any legal consequences. So the parties did no more than discuss and concur in a proposal for the plaintiff to receive a regular dress allowance that they considered would be appropriate to their circumstances when they got married. So again, this was influenced by an English case. Remember, back in 29, English cases were what? They were our final court of appeal was English, Privy Council. So when you bring in an English case, it could be a binding precedent, not just persuasive. So that's what's happening here. Balfour and Balfour, 1919, except rather in that case, Balfour and Balfour, the parties were married at the time the promise was made. In Cohen, the promise had been made while the parties were engaged, but a contract to marry had been made before the promise to pay the dress allowance had been made. So the judge was prepared to find in such a case that it probably didn't matter that the parties hadn't actually married. If the parties were living together in harmony at the time, the courts are very reluctant to find that the parties intended to create legal relations because there's usually no evidence suggest that the marriage has broken down. What is all of that about? Remember, we said that the reason for our presumption that you don't want to go to court is to preserve this relationship that we call marriage. If the marriage has broken down, then there's nothing to protect. So that becomes even stronger evidence to suggest that maybe then this was an agreement that they wanted to be legally enforceable. So let's take this scenario. A married couple, Cohen and Cohen. Okay? They decide to separate. They're not happy with each other, so they said, look, let's separate. Great. let's assume that they have some financial problems. So they can't separate immediately. So what they want to do is to continue living together for 2 years, and at the end of that 2 years, they finalize their divorce. So they agreed to be separated, but still living in the same home or house. During that period, Cohen does exactly what you have here. Now you go back to exactly the same facts. So he promises that he's going to pay his estranged wife an allowance. You think that the outcome of that case is going to be the same as this one?
Potentially not.
Why not?
Well, because they're still married and he's still sort of agreeing to pay off all of his, well, he's agreeing to the thing, like he's continuing the payoff of the dress.
Okay.
Still.
So in this case, did they find that this agreement was intended to be legally binding? Just read what you have. Did they intend for this agreement to be legally binding on the facts? What did we just say? What did the court say?
The court said the fact that they weren't, the fact that they were living together in harmony at the time of the agreement, they found that they had intended.
It didn't intend such an arrangement to have legal consequences. This is our case, right? Now I'm telling you, I will change this a little bit. And how am I going to change that? By saying that these two people, Cohen and Cohen, were living together as estranged husband and wife. Does that change the outcome? So let's start from the beginning. Why do we have this presumption that in a domestic arrangement, like between husband and wife, there's no intention to be legally bound? We said the reason for this presumption is to protect the marriage relationship. So it doesn't break down if they go to court. Yes? Now, if I'm telling you that the marriage arrangement, the marriage relationship has broken down already. So these people are already separated. But they decided to continue living together for financial reasons. It has nothing to do with continuing to be married or because they love each other or anything like that. So the marriage relationship has broken down. But then Cohen comes and says, look, I will make this arrangement. I will keep paying you that much, until maybe we finish our separation period or whatever. Do you think then that that agreement would be enforced in a court of law?
Well, the facts say that there isn't an intended legal agreement, so...
Okay, someone else. Damien.
You would have difficulty proving that the marriage had broken down to such an extent that it couldn't be.
They will tell you. They will tell you that we have agreed to be separated, and we are separated, so we're not having sex anymore. We have nothing to do with each other, except that we just have to live in the same place because of financial issues. Is that enough? They will tell you that. They will go to the judge, and the judge is going to ask, is that the case? And they will say yes. And Cohen, the husband, is going to say, yes, I agree. Now, do you think that his promise to pay that allowance would be enforced? It would be, I think. Why? Because the policy reason for the presumption is non-existent anymore. The marriage relationship has broken down. Whatever they talk about after that, they contemplate this is something that I can take you to court for. Okay. All right, let's look at more examples. The same page, 247, Shortall and White. This is 2007. The parties had lived in a de facto relationship that had broken down. But they continued to see each other. After a counseling session, the respondent had said she wanted some security. And so the appellant gave her a letter indicating that he held some shares in trust for her in a public company. So when you get to such relations later on in life, be careful. Be careful. However, the appellant said he would not sign such a letter unless the respondent gave him a check for $22,000, which she did. The appellant then gave the respondent a letter stating that he held 220,000 shares in a company in trust for her, and that he would transfer the shares to her. Unknown to the respondent, the shares were held by a third party and could not be transferred on the agreed date. So when the appellant refused to honor the agreement, she sued. Why? For breach of contract. And there's also something else, another cause of action called breach of trust. Trust as a legal instrument. We're not going to talk much about that here. So she sued based on the appellant's failure to transfer the shares on request, and the court at first instance found that the letter gave rise to contractual obligations, and it was this decision that the appellant appealed. He doesn't want to pay. He's saying this is a domestic agreement. Can the presumption that no legal relationships are intended be rebutted where the parties are not living together at the same time an agreement is reached between them? Okay. So the interpretation of this is a bit different from the hypothetical we were just talking about. My hypothetical area was that they continued to live together. So it's even, so this is how you write the exam questions. So this was even closer to make it harder to see, whether it's going to be rebutted or not. But this is easier to rebut because they see each other, but they are not living with each other.
Why do they continue to see each other? What does that mean? They just see.
So like friends. No sex. Okay? Just friends. They are not in a de facto relationship anymore. Decision. The presumption against an intention to create legal relationships doesn't apply when the parties are separated. Okay. Does it apply when the parties are separated but still live together? What is important? That they still live together or that they are separated? You can be separated and you can still be living together. Yes or no?
Yes.
What is important in this decision? That's the kind of question that would come on exam. Sorry. So instead of saying that they only see each other, I will make it harder and say not just that they are seeing each other, they live with each other. Does that still mean that they are in a de facto relationship? Or could they still be separated and living under the same roof?
They could be separated and living on the same.
Yep. So what they say, it's important to look at the relationship between the parties at the time the agreement was reached. In this case, the parties had separated. In Cohen, the one before, the promise was made before the relationship had broken down. Okay. All right, that's enough of this one. Let's move on. Let's go to 248. Ashton and Pratt, number 2. Ashton had provided paid escort services to the late Richard Pratt, which ended when Ashton married a third party in 1997. They had an agreement for escort services, which ended when Ashton married someone else.
What do you mean by escort services?
Oh, so what do we mean by escort services? So this is sexual favors, okay? So it's when you get someone to do something sexual in nature for you, and you pay them for that.
I had a feel like that was it. I just wanted to...
That's the confirmation.
So in other words...
So it's like 50 Shades of Grey
Ew.
without the spanking.
Ew.
All right? Following the breakdown of that marriage, which marriage? Ashton's marriage to a third party.
Yes.
After that breakdown, contact between Ashton Pratt resumed in October 2003. 6 years. They couldn't keep away from each other. They went back to the escort services. In November 2003, 1 month later, Miss Ashton contended, she's claiming, she's alleging that Mr. Pratt had promised her that if she again became his mistress, he would establish a trust. What's with these trusts? For $2.5 million this time around. Not $22,000, $2.5 million for each of her 2 children from that marriage to the third party, which was in 1997. So now she has 2 children from that marriage. Plus, pay her an annual allowance of $500,000. Plus, an additional $36,000 per annum for rental assistance and $30,000 for travel expenses. Okay. This is what she is contending. He promised me this, and this. So, one of the issues was whether these promises made by Mr. Pratt were intended to create legal relations. So we're not saying whether he made or not these promises. Let's say he made these promises. So what? Does that mean he intended that she could actually go to court and say, give me the money? He's dead already, right? So the decision was, the arrangement was a social one. Although the escort service industry, if you didn't know, is a very big component of any economy in the world. The only difference, some countries make it illegal, some countries make it legal. The presumption, so we go back to this presumption, because it's a social one, the presumption is that there's no intention. So the presumption that the parties did not intend to create legal relations was not rebutted. So they don't want to give her any money. Therefore, a contract was not intended. Okay. Let's look at the comment. The intent of the arrangement was to establish a mistress relationship, and that such a relationship was social. Even though there's money, right? She's paid for it. This meant that the parties did not intend to create a legal relationship. So the onus was on Ashton to rebut the presumption, which meant looking at the totality of the agreement and then deciding whether a reasonable person, so it's an objective test, in such a situation would have intended legal relations. To an ordinary person, the actions of the parties would not have suggested they intended a legal relationship. Why? So this is the crux of the matter. Neither party sought legal advice or reduced their oral arrangement to writing, nor did their subsequent conduct or communications suggest that a binding contract was intended. Excellent. So, if you have seen the 50 Shades of Grey movie, the first movie, does this apply there? The parties had sought legal advice in that movie? Yeah? reduced their oral arrangement to writing? Yeah? And didn't their subsequent conduct or communication suggest that a binding contract was intended? In fact, they met to discuss the contract. So if we assume that that type of contract is legal, and legality is going to be discussed later on when we come to the validity of contract, so it's a different analytical structure, assume for the time being this is legal. If it's legal, then the 50 Shades of Grey scenario would actually convince the court that what? The presumption is rebutted because they intended this to be legally binding. So that's how we do it as an exam question. Yeah? We might even give you Ashton and Pratt, the same names, to make sure that you go and check that, oh yeah, just copy, because it's open book, right? But the fact is that we change the facts that they are more like 50 Shades of Grey. So if you come to the same conclusion, it doesn't make sense. All right. What about this reflection? Should a mistress relationship, these escort services, be considered to be contrary to public policy and make a contract void? Void means it's not enforceable. You can't go to court and say, pay me for my services. What do you think? Should that be the case? Is that actually contrary to public policy?
Well, I would say no, because even though I don't agree with it, she is technically providing services to another person.
But it's immoral, don't you think?
Yes, I do agree it's very immoral, but unfortunately...
Is it immoral?
It depends on what country you're in, I suppose.
Okay. So, again, we said that law is relative.
Yes.
Okay? In a country like the Netherlands, for example, probably they would be looking at you, what's wrong with this guy, It's very normal there that you have escort services. Okay?
Well, it's illegal in this country, isn't it?
Well, yeah, it depends on certain jurisdictions. It depends on how you do it. Okay? I mean, do you know that there are brothels, for example, in Queensland or not?
I did not know that.
Okay. Do you know that there are brothels in Queensland or not? Okay. Does that mean that this kind of service is legal or illegal? It depends. Because they put, as usual, they will put some, certain limitations to make sure that if you are going to provide the service, it has to be done in certain ways.
Isn't a brothel like a legal establishment, though? Like
Illegal or legal?
legal.
Legal, of course. That's what I'm telling you. Brothels exist, okay? So in Queensland, there are brothels, okay? That's not exactly the same thing as saying mistress relationship, okay? Okay. All right. Again, we'll leave it there. It just really depends on society, so the morality of what we are doing, whether it's something acceptable or not. This is not very different from what you're hearing on the news today. In relation to what? So I'm not saying that's mistress relationship, don't misunderstand. But you now hear about same-sex marriage. And the idea that we want to have a plebiscite, a postal vote, to see whether we want that to be part of our society or not. Again, it depends on the society. In the Netherlands, they had it since 1973. It depends. It depends on society. You can't push society. You have to give it its time to move towards what other people have already achieved or whatever. Okay? I'm not saying it's right or wrong. What I'm telling you, it's the same story. We want to change the law. And the law has to be changed from the moral background. Same idea that they are trying to ask about in this case reflection. 249. Wakeling and Ripley. 1951. The defendant was a wealthy old man who lived in a large house in Sydney. The plaintiffs, his sister and her husband, they were in England. He wrote to them, to the sister and her husband, asking them to move to Sydney. He's an old man. Okay? He promised to provide them with a home and leave them all his property on his death. So he promised. Remember, contracts always start with the promise. On
Bilateral contract, is it a promise as a promise? Or?
Yeah, if it's bilateral, then there will be promises on both sides. If it's unilateral, it's one side that promises.
And so this would be a unilateral contract?
Because they will, let's see, because they will accept by moving. Let's see. On the basis of his promise, they sold their home and the husband resigned his job. Okay, so they left England, came to live with him in Sydney. After the plaintiffs had lived with this old man for a year, he quarreled with them. So there was some disagreement. Sold the house and changed his will. So, of course, the sister and her husband sued for breach of contract. What do they want? They want compensation. So the issue, because we're not talking about anything else today except intention, was the consequences for the plaintiff of the defendant going back on their word are sufficiently serious. Is this enough to rebut the presumption that the parties didn't intend to create legal relationships? When you look at it, you'll see that this is some sort of a family social arrangement. Yeah? The old man, his sister, and her husband. But they're saying, even though that's the starting point, that's the presumption, we have enough evidence here that the plaintiff, the onus was on them, can actually rebut the presumption and convince the court that in this case, the parties, the sister and her brother, intended for this to be legally binding. And the court agreed. There was ample evidence to indicate that the parties did intend to enter into a binding and enforceable contract. Why? They don't say why. But why? Why do you think that's the case?
Because they had to, I think there would have been because each party was making a big decision, like they were literally selling everything they knew and moving to a whole different country. So you'd think there would be a contract in that.
Okay. So someone else wants to say something? So why do you think the court was convinced that in this case they intended this to be enforceable? What did the parties do, especially the sister and husband? They sold their house, they quit their job in order for them to move with this guy in Sydney.
I would say,
Yes?
I would also add to that the older guy who, on his side of the agreement, he obviously bought the house for him and he changed his will as he initially
The first time.
said he would.
Yeah. Okay? So all of this shows you that the seriousness is not an oral agreement. Okay? There are consequences to both parties. All right, let's leave it there. Let's look at something else. 251, Teen Ranch. Okay? So, Teen Ranch and Brown, 1995, New South Wales Court of Appeal. Brown was a volunteer. He was a volunteer worker at a non-profit Christian youth center. He received accommodation, food, and the use of the camp facilities. And he was expected to obey camp rules, but, most important thing, no wages. While working at the camp, he was injured. So that takes you back to negligence. And he claimed workers' compensation. What any of this has to do with contracts? So the issue, was there a contract of employment, okay, between Brown and the Teen Ranch? Because if there is one, that would entitle him to be covered by this compensation. There's a gateway that stops you from getting workers' compensation unless you can establish that that injury that you have sustained was during carrying your job description activities or tasks under a contract of employment. So you have to establish first that there was a contract of employment. If yes, you can go and apply for that compensation. What did they say? There was no evidence of intention to create legal relations. Okay? But even if there were intention, the fact that Brown's labor was voluntary, no wages, would suggest that there was no consideration present, which is muddying everything up. Okay? They are talking about two elements already, and they're talking about them at the same time. Consideration is a very separate element. The legal issue that arises under consideration will arise because there are no wages. The legal issue under intention is the nature of the relationship between the parties, i.e. that this was a voluntary agreement. All right, so for the purposes of determining whether the parties intended to create legal relations, is it better to work for an unincorporated or voluntary association or an incorporated association? What do you think? Which one would make it easier for you if you are in this situation to go and argue that in fact our agreement is legally binding? So of course, if it's incorporated, because that brings you under the incorporation rules, and that means that you have a more business-like situation. So more likely that the agreement between you and this entity is going to be classified as a business entity rather than maybe that like a social agreement. Okay. Let's keep going. Hermogenes, 252. From 2002. So this is something about a religious sort of situation. There's an archbishop, his name is Hermogenes, made a claim under, again, an alleged contract of employment. Again, the story, whether there's a contract of employment or not. He's alleging there is one. For payment in respect of unused annual and long service leave upon termination of his employment. So he's saying there was a contract of employment. Under this contract of employment, I'm entitled to certain types of leave, and I didn't take that type of leave, so now you have to pay me in lieu. You have to pay me money for that amount of time I didn't take. The church argued that he was not entitled to these payments under contract law. Why? Because there was no intention to create a contract of employment. So they're saying we never intended for you to become employed. Okay? We never intended for this to become a legally binding arrangement. The issue, can this minister of religion be an employee of a church or a church agency? Was there a clear indication of contemplation of a legal relationship? They decided while there was a non-commercial relationship between the parties, so this is spiritual, the appellant had established that the agreement was intended to be legally enforceable in this case. Why? What do you think made them believe or accept that that kind of presumption in this case, so it's non-commercial, the presumption is that it's not legally binding. But they said that the minister was able to provide them enough evidence to rebut this presumption. Why? Can you think of any facts that would make you believe that that's the case? Let's look at the comments. The decision effectively extended the class of cases in which intention must be positively proved by the plaintiff to the hiring of ministers of religion. But the High Court also made it clear that its decision would not necessarily have application to other churches. Okay? With each case having to be treated on its own facts. So it says, what is the impact of Hermogenes on the role of presumptions? This was pretty much what we talked about in the previous chapter in relation to agreement, chapter 8, when we said that there was a move away from the traditional analysis of offer and acceptance because of the complexity of certain types of contracts. And the same thing is here. So when we talk about these presumptions, whether it is for a commercial or non-commercial agreement, those are only the starting points. So you have to look at the whole factual matrix in order for you to establish whether the parties intended, in fact, for their agreement to be legally binding or not. All right, let's continue. 253, PERT.
I don't think it goes down any further than that.
Yeah, I can see that. Okay. Let's look at PERT biotechnologies. Professor PERT owned the intellectual property in a process that digested organic waste, which means that you can leave no solid residue and solubilizing the minerals. So of course, as it says, it's very valuable because what you are doing is taking something like waste and turning it into solid residue which can be disposed of easier. Or maybe even used as an input to a different industrial process. PERT met with potential investors, okay, informal occasions. At the last informal meeting, there was a lunch in a hotel room. The establishment of a company to raise capital was discussed. So he's looking for investors. No notes or formal records had been kept of previous meetings, which had not been intended to create legal relations. Rather, they had been intended to reach some general consensus on how best to commercialize the technology. Again, a memo, a letter of intent, was drafted. Okay? They proposed, among other things, the investors, the establishment of a company of which there would be the directors. Okay? They discussed the shareholdings, raising of capital, presentation of this technology to a water corporation. They discussed licensing agreements or arrangements. If the appropriate level of financial and administrative support could be obtained. The if is in bold. And that the parties at this stage, so this was in the letter of intent. The parties at this stage do not seek a contractual obligation, but require, for the time being, a clear indication as to their respective interests and intentions. Sign the letter, okay, and then they obtain something called the shelf company. Okay, so you can actually buy these off the shelf. So it is already registered, has a name. You can just buy it off the shelf rather than go and have to register from scratch. And it was called by his name, PERT Biotechnologies Proprietary Limited. Issue. Did this letter of intent plus the conduct in this informal meeting lead to the conclusion that there was an intention to enter into legally binding agreement? And the court said the subject of the agreement was commercial, so it's a commercial agreement. But when the surrounding circumstances were examined, it was unlikely that an objective observer, so you're using the objective test, objective reasonable person test, would reasonably conclude that the parties intended to create a legally binding agreement. Why? because explicitly they say they don't intend to seek a contractual obligation. What does contractual obligation mean? It's an obligation that you can then, if someone breaches, take to court. So no intention to be legally bound. Okay, comment. The execution of this letter and the negotiations suggested that the parties were still negotiating and that they intended to execute a written document before being legally bound. Okay? So the indicia, if you like, what led the court to find that there was no intention to be legally bound, things like the meetings between the parties had always been informal. So if you want to take this and change it into something like an exam question, yeah, you can play with some of these facts. The meetings between the parties had always been informal, even if it's a Skype meeting. And no effort had been made to keep notes or record minutes. That some of the terms of the letter of intent were unclear, and the commercial potential was such that it was highly unlikely that the defendant would agree informally and without documentation to assign their rights. If you were in a law school and if you were law students, okay, your exam will actually come with the letter of intent. There will be a letter of intent signed in the exam. It could be 2 pages, 3 pages. So you have to go through the whole letter of intent, a real letter of intent, right? And then decide based on these facts what happens. But that's of course not what's going to happen in this course. Of course. All right. Let's go on to 255. So at most your exam questions would be half a page. So nothing. So that's why you go back to the specs for this course. You'll find that it says you have to amass this introductory. I don't know if it's still there or not. Yeah. Yeah. Objectives, see, introductory level of critical legal thinking skills. So I don't expect you really to get to the level that we teach elsewhere, but at least you will be able to do the elementary stuff. Okay, let's go on then to page 255, and Bank Bruxelles, Lambert, and the Australian National Industries from 1989. The defendant had refused to give a guarantee, as in Kleinwert. Kleinwert is the case that's being discussed above. Let's look at Kleinwert as well, which is this case here. So we're not talking about a letter of intent, we're talking about a guarantee. In the case of a guarantee, the liability of the guarantor arises on default of the subsidiary. So if you have a parent company and a subsidiary, the parent company wants to give a guarantee to someone that the subsidiary is going to actually deliver if they are taking a loan, if they are going to require payments. So the problem with a letter of comfort, so this is not really a guarantee. So if they refuse to give you a guarantee, the second best comes as a letter of comfort. What's the problem with it? It may be difficult to ascertain whether it is intended to have a legal effect. So the parent company doesn't want to give you a guarantee. Instead, they want to give you simply a letter of comfort to the effect that, yes, we are, we are aware of the situation and we know that the subsidiary is going with this, for example, loan, whatever. So there was this case, 1988, Kleinwert. In that case, there was a letter of comfort and it was given in relation to a loan. So the loan is being given to a subsidiary. Letter of comfort is given from the parent company. Initially it was £5 million, but later it was also increased double to 10 million. This was given to a wholly owned subsidiary company of the defendants. Wholly owned means that they own all the shares of that subsidiary. The parent company owns the subsidiary 100%. The defendants had refused on policy grounds to guarantee borrowings, but entered into a letter of comfort, and they said this in the letter: it is our policy to ensure that the business is at all times, so this is subsidiary, in a position to meet its liabilities to you under the above arrangements. Out of policy, we make sure that our subsidiary meets its obligations. It's not saying that we're going to guarantee it.
A letter of comfort make sure the subsidiaries meet its obligations, like you said.
So the comfort is given to the person who's giving the loan. Yeah? Saying, yes, go ahead and give them the money. So our policy is to back them up. But they're not saying that we guarantee it. It went to court because subsidiary defaulted. What did they say? The letter of comfort, okay, was not a promise to pay the loan. Okay? The words were not seen as promissory. Okay? However, let's compare it now with this case here. The defendant had refused to give a guarantee, as in Kleinwert, okay, and the bank required a letter of comfort in a form satisfactory to it. That was the condition for the loan. The second paragraph of the letter stated it was not the defendant's intention to reduce its shareholdings in the borrower. Do you understand what that means? You own the company. I'm the parent, that's the subsidiary. Now the subsidiary is going underwater. I know that there are problems with loans. Sometimes the parent company might try to bail out by selling their shares. Try to offload the loan, try to offload the company to someone else. So here, they're giving you a guarantee, or, well, they're saying basically that we will not do so. They don't have intention to reduce its shareholdings in the borrower, and that should it decide to do so, it would give the bank 90 days notice. So if we decide to sell our shares, we will take that to you first. We will agree first. If you say yes, we'll go ahead with it. The third paragraph of this letter said this: we take this opportunity, so we're looking whether these are promissory words or not. We take this opportunity to confirm that it's our practice, our policy, our practice, to ensure that our affiliate, i.e. subsidiary, will at all times be in a position to meet its financial obligations. It's just similar to the previous case. As they fall due. These financial obligations include the repayments of all outstanding loans within 30 days. So, the question was there an intention to create legal relations? The decision, the wording was promissory. Why? So, they said promissory and intended then to create this legally binding obligation. So, of course, the presumption is that they intended to do so, but as noted above, whether the statement is promissory or not is a matter of construction. So you are trying to construe what's written. And while letters of comfort have traditionally not been regarded as legally binding, traditionally, Australian courts have preferred the use of an objective test to try to determine, from looking at the parties' acts and conduct, including their statements, whether there's a clear indication of what they intended. Then there's something about reflection in relation to the ACL. We'll leave that for now because we haven't covered the ACL. But I take you back to comparison of this paragraph and this paragraph. Okay? Let's just look at these two different letters of comfort. The first one says, it is our policy to ensure that our affiliate is at all times in a position to meet its liability to you under the above arrangements. All right? These guys say, we take this opportunity to confirm that's our practice, okay, to ensure that our affiliate will at all times be in a position to meet its financial obligations as they fall due. These financial obligations include repayments of all outstanding loans within 30 days. Here, they said there was no promise. It's not promissory. Here they said it's promissory. How come? Why is the first one not promissory and this one is promissory? So someone is saying Probably the difference between them is what?
The second one includes the clause that repayment of all outstanding loans will be paid. The other one
So in the Bruxelles case it says what? That our affiliate will be in a position to meet its financial obligations as they fall due. Is that what you're talking about? The last sentence, and it says these obligations include repayments of all outstanding loans within 30 days. Why is this sentence enough to change it from non-promissory to promissory? Tim.
With the second case, they use the word practice instead of practice. That means it's what they do.
So if I take that out and say it's our policy.
The policy is just what they intend to do.
So what is a policy? A policy is a set of principles. So principles really feed into practice. Or are you saying that this practice refers to something other than policy, something like a procedure, something like a rule? Okay, good argument. But what else? So let me put it to you like this. Let's leave the practice there, Tim's argument, and take out the last sentence as an exam question. Is it now promissory or not? So just say, we take the opportunity to confirm that's our practice to ensure that our affiliate will at all times be in a position to meet its financial obligations as they fall due, full stop, nothing else. Is that promissory? You still think it's promissory because practice. Okay? Let's take out practice and put policy. So let's say we take this opportunity to confirm that's our policy to ensure that our affiliate will at all times be in a position to meet its financial obligations as they fall due. These financial obligations include repayments of all outstanding loans within 30 days. You think this is promissory now? Anyone else? Tim thinks the only thing that the whole thing turns on whether you use practice or policy. Anyone else wants to give us maybe a different take? The lady at the back said what? Said that it is the last sentence. It's the last sentence. And why do you think it's the last sentence? Specifically talking about, yes, Damien.
So specifically talking about outstanding loans.
And within 30 days. You remember what we talked about when we talked about offers? If I want to sell my pen to someone, and I just come and say, I want to sell you my pen, is that an offer? No. Why? Because there's not enough specificity. I'm not giving you the terms. But if I say, I want to sell you this pen for $10, is this now an offer? I want to sell you this pen for $10, payable by cash, deliverable to me today before 4 p.m. by return of this email. Is this now an offer or not? The more specificity you put into it, the more you give it. Why is it an offer? Because you're trying to establish an agreement. If this person comes back and says yes, then you have an agreement, and it's very obvious from this kind of interaction that you have an intention to create a legal relationship. The more specificity you put, regardless whether you call something a letter of comfort or a letter of intent or memorandum, whatever you call it, what's important is what kind of details you used to deliver what you intend to do. The more details, the more likely you are talking legal matters, legal obligations, so you are going to be bound. All right. Two more. Shall we do the two more, or you want to stop here? Shall we take 10 minutes break and start on the tutorial? Or you want to continue with the last two? Yes, no? Don't care? The last two are going to be the woolen mills. Let's do them very quickly. Just quickly. All right. So this is from 1954. The Commonwealth government announced that it would pay a wool subsidy for wool brought for the purpose of manufacturing in Australia. You can tell that this is, ancient history. The plaintiff bought wool because we don't manufacture anything anymore in this country. The plaintiff bought wool and received a subsidy. But a dispute arose after the scheme, this is the government scheme, finished about the amount, but a dispute arose after the scheme finished about the amount to which it was entitled. After the scheme finished about the amount to which it was entitled. It brought an action. So who brought the action? Australian woolen mills against the Commonwealth government, alleging that there was a unilateral contract. Okay, so this was a scheme. If you give me this, I will give you that. Okay, so the subsidy is what they get. Issue. Was the government, by doing this scheme, intending to enter into a contractual relationship? Without more, what do you think? If the government comes and says to these people, you know, give me the wool and I'll give you a subsidy, would pay a wool subsidy for wool bought for the purpose of manufacturing in Australia. Does this look like enough specificity to say that we have an intention to be legally bound? Is this a social arrangement? Is this a business arrangement? So someone is saying yes, nodding yes, this is business arrangement. If it's a business arrangement, then the presumption is that there is an intention to be legally bound. That's our starting point, right? But they're saying what here? So let's see how they bring this out. It says there was no intention. How come? Why? No can we presume an intention? Why? There was no statutory authority to administer the scheme. Okay? There was no legislation behind it. And the subsidy was an attempt to maintain a price structure for the Australian manufacturers of woolen goods in the post-war period, 1954. There was no intention on the part of the government of the day to create legal relations. Rather, it was government scheme to promote the wool industry. The reflection, why should there be any distinction between administrative arrangement and a contractual one for the purposes of determining the intention of the parties? Shouldn't the outcome be the same in either case? If the government comes out and say, I will pay you money, subsidy, for wool, because I want people to get the wool so that we have the industry, so we have the added value. And then you come around when the scheme stopped and say, actually, I'm not bound. I never intended to create a legal relationship. Does this make sense? So the reflection is, what's the difference? If I give you an administrative arrangement, I'm the government, Commonwealth. What difference does it make if it's something that's backed by legislation or not? If the government comes out and say, I want to contract with you on this basis, I promise you this subsidy. What more do you need to give you an intention that they are legally bound? But this is to show you that the logic that we use in law is called fuzzy logic, if you've heard the term, fuzzy logic. It's not hard logic. So sometimes you'll find very strange outcomes like this because of policy grounds. We said that there's separation, right? The separation of powers between the executive and the legislative and the judiciary. But you can see sometimes that things are not quite that way. All right? And quickly, the last case is Carlyle. I will leave it for you. We have discussed it before. You can go through that. Let's have 10 minutes break. We'll start 10 to 10. Thank you.